Welcome back to this second part of Law Sessions Co-Ownership Dealing with Trust. Now, in the first segment, we considered express declarations, and we also looked at statutory trusts. What we want to consider here, though, are the areas which tend to be fodder for any exam question, and those areas tend to be resulting and constructive trusts, and of course, when you look at proprietary estoppel as well. Now, as we continue on by looking at this area, the classic situation is where a resulting or constructive trust arises in the context of the family home, when the family home is bought by one person, usually the man, and he's the legal owner, and his partner spends time with the children and contribute to the finances by working part-time. The situation is then that the relationship breaks down, and the question is whether the woman has acquired any right in the house that is recognized by law. Now, the first thing is that she has no rights at law, as it is not on the legal title, but equity may recognize her contributions in the form of an equitable interest based on fairness and justice. And this equitable interest arises under a resulting or a constructive trust and will certainly give her rights in the property. The other scenario, of course, to consider is where you have two persons who have bought property, again in the context of the matrimonial home, but unfortunately they have no express declaration as to how the beneficial interest should be considered. Now, as I said in the last segment, if there's an express declaration of trust, then you take that as a gift. Why? Because what is being considered is not the area we're about to discuss. Rather, it is possibly a severance question. So if the examiner tells you that there is an express declaration, then they are not seeking to have you decide on the equitable interest by way of quantification. But if it is that the examiner only tells you that the property has been transferred to A and B, and there's nothing in the question which suggests that an express declaration is present, then that's where we may need to discuss whether there is a resulting trust situation, a constructive trust situation, or whether there is a proprietary estoppel situation. Let's start with the resulting trust. This is where the trust results by implication. So, for example, the husband and wife have behaved in such a way that you can imply what they meant to happen from their actions, or certainly their contributions. The constructive trust is constructed by the courts when there has been a behavior that merits the award of an interest in equity. As it relates to proprietary estoppel, this is where a party has been led to believe that they have an interest and they have relied on that representation, and it would be unconscionable to resile from that position that they have been led to believe. The classic type of proprietary estoppel situation in exam questions, of course, is where, for example, you see the examiner tell you that A and B purchased property and it is either in A's name or A and B's name, and then, for good measure, the examiner says C, usually it is one or the other party's mother or the mother-in-law, has moved into the premises and there's an annex built by the mother-in-law and she has expended monies to do that. Well, the mother-in-law would have been led to believe that she has an interest, or she would led to believe that she can stay on the premises having built this granny flat, and as such, the courts may consider that there may be an equitable estoppel or proprietary estoppel situation in her favor. Whether you're seeing a resulting or constructive trust situation, land is now co-owned beneficially by the husband and wife. So if we go down the route first of the resulting trust and consider that, The general idea is that if A transfers the legal title in the property into the name of B, the law does not presume a gift. It presumes a trust for A. So if I buy property in your name using my monies, then the first starting point that the court comes from is not that I've gifted it to you, but rather that it remains mine because you did not pay for it. That is, in the situation, it presumes that A's intention was to benefit himself. It was not to benefit B. The beneficial interest, therefore, meaning the equitable interest in the property, will spring back or result to A. So A buys property in B's name. There is a resulting trust in A's favor. The presumption arises of a resulting trust in A's favor and is a presumption as to the provider's intention. If the title owner wishes to rebut it, he will have to bring sufficient evidence, positive evidence, that there was a different intention. So, for example, show that a loan or a gift was in fact intended. Now then, how does a resulting trust in the context of, for example, the contributor getting a share in equity? Well, it can be by way of a contribution to the purchase price. And the case for that, of course, is Dyer and Dyer. A resulting trust always approaches from the standpoint that in relation to the proportions of the parties, it is split proportionate to their contributions. And so the contribution can be by way of the initial deposit. It can be by way of legal expenses. These are also seen as a contribution to the initial purchase price. Now, in the case of Ree Rogers' question, a 1948 case, the wife paid an initial payment of £100, while the husband paid the remaining £900, and this was through a mortgage, which he paid on. The courts held that the wife had a 1/10 share on the basis of a resulting trust. Now, payment of the mortgage, where both parties contribute from the outset. The case of Gissing and Gissing says that this will go towards there being a resulting trust in favor of the party, for example, whose name is not on the title. If one party contributes later to the mortgage, one party pays the household expenses, enabling the other party to pay the mortgage. Starting point is that you may be able, or that party may be able, to get an interest in his favor. Now, you have to be very clear on this, because it doesn't mean that if you move in with somebody and you pay the expenses, you buy the food, you pay the electricity, that you will get a share. That's not the point. The point is, if you pay the household expenses which enable them to pay the mortgage, that might give rise to a share. Cases for this, of course, are Gissing and Gissing, Bernard and Josephs, LeFaux and LeFaux. The point being that if it is that X and Y move in together and X is earning £800 and the mortgage is, say, 300, X can pay it by himself. But if X takes a mortgage whereby of his £800 salary, he's paying £780, then he still has electricity and gas and all the rest of it. And if it is that Y pays towards this, then arguably he has allowed him to be able to afford the mortgage. So in order to get a share, contributions to the mortgage enabling payment of the mortgage are good enough, but contributions to food, household expenses, and so on will not help, and the cases include Gissing and, of course, the famous case of Burns and Burns. The presumption of a resulting trust, as I said earlier, is excluded by evidence of a gift or a loan, and the case for that, of course, is Ray Sharp in 1980, where it was held that the aunt had loaned the nephew money, so there was no resulting trust. The presumption of a resulting trust, again, the point that if I use my monies to buy property in your name, is a presumption which can be rebutted. Now, it can be rebutted, as I said earlier, if I can show that it's a gift or a loan, or it can be rebutted by way of the presumption of advancement, another presumption. It is an old-fashioned concept, and it works like this. The presumption of advancement says, let's assume a husband buys property in his wife's name. The courts will say that although the starting point is that there's a presumption of a resulting trust, the fact that he's bought it in his wife's name means the wife can now argue that there was a presumption of advancement in her favor, because this old-fashioned concept sees the man as the provider. So it is saying that if he bought his wife a house, meaning in her name, he meant to advance her. And the same applies if he buys property in his children's name. The way you argue it is to say that there is a presumption of a resulting trust, which is then rebutted by the presumption of advancement, which itself can be rebutted by evidence to the contrary. So the man says, hang on a minute, I bought it in her name, but that's because my accountant says it was the best thing to do, and we weren't really seeking to avoid taxes. We were simply doing it based on evidence, and she knows this. So if it is that the wife then seeks to plead the presumption of advancement, the husband can bring the evidence in relation to the accountant to show evidence to the contrary. Equally, if you lend me money to buy Blackacre, and then I use the money and buy Blackacre, and Blackacre increases in value, and you think, hang on a minute, I am going to plead that this is a presumption of a resulting trust because it's my money, I can rebut that by showing the court that no, you do not have a proprietary interest in Blackacre. You loaned me the money. So when I use your money, let's say £100,000, and I buy Blackacre for £100,000, but resell it to a developer for £500,000, I only need to give you back the loan of £100,000, because I can rebut that presumption by saying that it was a loan, or at worst, possibly a gift. Watch the examiner for situations where it says, for example, the wife's mother or father gave the couple money to buy their first home, i.e. Blackacre. If that is the case, then the starting point for that parent is to say there's a presumption of a resulting trust, but that can be possibly rebutted. So with contemporary society, of course, by and large, the presumption has weakened terribly. In respect of the quantification of the shares in a resulting trust, it is proportionate to the contributions made by the parties when they initially purchased it. So says the case of Petit. So if there is no contribution by the one party, that party is unlikely to get a resulting trust. Now, does it matter if one of the parties has exhibited, for example, fraudulent behavior in respect of the relationship? Well, the case that looks at this is Tinsley and Milligan. Now, Miss Tinsley and Miss Milligan were a lesbian couple who had purchased a property, and what they did was that Miss Tinsley used her savings together with Miss Milligan's savings, and they put the deposit down on the property. But they then sought to perpetrate a fraud on the council or on the DSS by saying that Miss Tinsley was renting from Miss Milligan. And what they did then was use the rental income to pay the mortgage. Now, you might need to understand the context of this, because it is unfortunate that the welfare system, of course, in England at the time, provided that it would pay your rent, but it wouldn't pay your mortgage. Not unless, of course, it was an interest-only mortgage, but that's outside the scope of this particular lecture. The point was, if Miss Tinsley claimed that she was renting, effectively the entirety of the mortgage would have been paid. The question then is, could she get a share? Well, the court was split in respect of the judgment because there was a 3-2 split, because one of the things you have to consider here, it does appear as if the claimant was seeking to get a share based on a fraud. And one of the things that you have to consider, of course, is he who comes to equity must come with clean hands. And the fact is, if you're seeking a trust in your favor, have you acted with dirty hands, for example? The majority said that she did not need to rely on the fraud for her share because her share came into existence when she put down the deposit. And as such, she was able to, of course, get a resulting trust in her favor. There's been a lot of activity in this area, in particular the constructive trust, but the idea is that the resulting trust is still relevant in the context of the family home, and we will see that in a case called Lasker and Lasker in the next segment. You may not want to go to the route of a resulting trust, though, especially if there is a common intention to share in a different proportion than the amount of money is contributed. So let's say, for example, X and Y decide to buy Blackacre. X has £20,000, but X doesn't want to spend it. Y says to X, why don't you put your £20,000 in? And if you do, I will give you 50% as a share of Blackacre. Now that's an offer too good to refuse. So of course, you put your money in. The point is that from a resulting trust point of view, X would have a 20% share. But on a constructive trust point of view, he may very well have a 50% share. We are going to break briefly, and when we come back, we will consider the context of the constructive trust.